Hi, good evening, and welcome back to the business law or the contractual relationship session. So now we are going to discuss about the performance of contract. So we were discussing about the contracts, the business contracts, and how those are made, what are the conditions and terms, and so on and so forth. Now we are going to discuss about the performance of these contracts. What do you mean by performing? Well, let's say as an example, performing in the sense we are going to do the things. So we are going to do the necessary activities and whatever the terms and conditions mentioned in that particular contracts, right? So before we are moving to the lesson, you should know what are the things we are going to cover today. Actually, as the lesson now comes, I can show you define the performance of contract, and we are going to understand the um, parties to perform the contracts, as well as explain the concept of joint promises. There are sort of things called joint promises. I'm pretty sure that you may have already given some promises to some of the parties, right? So let's say and understand the activities of assignments of contract. There can be the agreements, or let's say some of the contracts can be assigned. Okay, so we are going to evaluate whether there's a possibility of assigning all these contract into parties as we want, right? So these are the basic things we are going to cover today, as well as some of the other features are also there, but I'm not expecting to cover those things within some of the, with the time schedule that I'm having. So because of that, we'll move to the session. What do you mean by the performance? As I told you earlier, you are going to perform, you are going to act, you are going to do whatever the things, whatever the terms and conditions mentioned in your contract. Simply by doing all these contractual terms and conditions, by acting all these, by conduct, or let's say by conducting all these terms and conditions included in your business contract, you're going to perform, in the sense you're going to do your responsibilities and duties. Okay, so that is basically a fulfillment of whatever the prescribed things in your business contract. It can be if you are the offeror, or you can be either offeree, but still you are going to perform that contract by doing so. So initially, I mean, very basically we can define the contract performance of the contract as fulfillment of respective legal obligations by the parties known as the promisor and promisee engaged in a contract, which are created under the contract. So there are terms and conditions where there should be two parties. I've told you in my first lesson, I've told you about the whenever we were discussing about the contractual relationships or the business contracts in a previous case. I mentioned there should be at least two parties, because you cannot make any contracts with you, right? There should be two or more parties. So the one who's going to give the promise, or give the sort of yes, of course, that is the promise, right? So that person will be known as the promiser, as well as the party who receives that sort of a promise will be called as, or will be referred to as, the promisee. So in that case, the either party, are going to fulfill all these necessary things which are mentioned in the contracts, is called performing the contract. So all the duties and responsibilities expressed by the, I told you about expressed terms and implied terms. So expressed by the terms and conditions, the either party is liable for performing them. Because of what? You know that, right? Because of what? Because you know, by attainment to a contract, in the sense you are going to bound by a legislative or a legal background to do something, right? So which is legally enforceable. Okay, so that is the definition of performing the contracts, performance of contracts. So anyway, while we are performing, some of the disputes can be happen if a party fails to do or perform some of the activities which are mentioned in the agreement, let's say prescribed by the terms and the conditions of an agreement. So because of that, you must know there's possibility of demanding for performance in these business contracts. So let's see how. So demand in the sense, now there's an activity, let's say the promisee can ask or demand, right? Demand the promisor to do so. Whatever the activity is agreed by the promisor to the promisee has to be done by, or has to be worked, has to be performed by the promisor itself, right? Otherwise, the promisee can demand the promisor to do them or to perform them, right? Rule 1, the promisor, simply the person who received the promisee, the person who received the promise from the particular promisor is entitled to demand for a performance from the promisor. That is there in legal rule, right? So a third party, let's say while you are attaining to the, or while you are becoming to a contractual agreement between the parties, the promisee, the person who receives the promise from the promisor, might have agreed with another party, what you call as third party, about something, right? Those are not valid in this performance demanding, because it has to be, because you haven't agreed with the, let's call, there can be, let's get two names, right? Nimal is the promisor and Sunil is the promisee. So Nimal, as the promisor, he's having the liability to perform all these acts to the promisee, that is to Sunil. So if Nimal doesn't perform well, or if in case of breach of any of the performance, or even if the if Nimal is not in a, or let's say in case of inability to perform the contract, so the Sunil can demand for it. But if Sunil has agreed for something, Sunil being the promisee has agreed with Amal, and Amal has given some other promise, Sunil, the Nimal is not liable for that particular promise, right? So this is a condition. So then the third one says that in the event of the death of the promisee, the attorney receives the right and is eligible to demand the performance on behalf of the promisee. So it says that when the promisee is absent, in a circumstance where the promisee is absent, so his or her attorney can represent him or her and demand for the performance of that promise. Right. So that is how demand goes. And there are so many parties to perform the contracts. Fine. So who are the parties? Basically by the professor, the promisor, right? I made a mistake, sorry. Promisor. Promisor is the person who promised to perform the duties and responsibilities to the promisee, right? So in an event you have some of the personal skills, let's say the person is a driver, right? He agrees to drop you somewhere. So in that case, if you are having an agreement between the parties, let's say the promisor itself has to comply that sort of an act, right? He has to perform, right? That is what you call as performance by the promisor. Then the second one is by the promisor or its agent. Let's say in an event of a company agreement, now you become, let's say, suppose you are the designated authority to sign an agreement, right? Okay, let's say you are the financial controller of a company. So you are going to sign a contract, you are going to give a promise to promisee, being the promisor, in an agreement. Now, in an event where you are going to resign from the company, you are just representing the company only. You don't have any sort of a legal, what do you call it, the binding to perform that particular agreement, right? It's going with the company, which is non-personal or which is impersonal, right? In that case, you can ask one of your agents to carry out the whatever the duties and responsibilities assigned to you by the agreement, right? And then by the legal representatives. In a case of death or in a case of insanity of a person who known as the promisor, the legal representative or the legal officer or the attorney of that particular promisor can of course conduct or can of course perform this contract, or let's say the promise, to the promisee. that is to refrain, or that is to omit and to mitigate the risk of less performance or undue performances. Then a third party, a third person, right? In an event when the promisee has received the promise from a third party. So third party is liable, as I told you earlier, though they have agreed between two parties, but still if someone has given, but it has to be in the whatever the agreement that you refer into, but it has to be coming from third party, right? It has to be coming from third party. Fine. So then we'll move. And when it comes to the promises, of course, now you make some of the promises. Now I know, right? Basically, you make some promises to your parents, especially. Oh, I mean, I'm not going on a wrong way, right? Promises in the sense you are making so many promises, I know, but still you are making some promises to your parents as well, right? I will pass the exam. Be careful, huh? Promises. Okay. So when it comes to the business agreements and things like that, you have some of joint promises as well. Not the individual promises. You might make some joint promises. How can you make? Let's say it's like Adi Haddenage Kandahaliya. Why? With some of people, let's say a group of people will make some promise to, especially not like the political parties, right? They also make the promises, but those are lies. But when it comes to the promises, of course, this should be, achievable and realizable. Don't make any lies like the political parties. Okay, right? So joint promises are the jointly or let's say the collectively made promises to the people. So we can easily define them as the promises which are made jointly or collectively by two or more parties. Two or more parties, right? Because right? There should be a team. And also the promises can be made to an individual or else the parties, right? A group of people, right? Okay. To another party or parties can be defined as the joint promises. Okay, we'll go further. Performance of joint promises. Now, when it comes to the performance of the joint promises, it's not very easy, right? Now, there are 2-3 ways of performing these things, right? With the nature of the joint promises, it may differ. Why? Because a single promiser, right, can make promises to, several, or let's say a group of promises, right? Group of promises. So which means there are people, those who accept your individual promise or set of promises. As an example, if A, B, C, 3 characters are there, right? You being the A, you're going to make the promise to B and C. That is one way of doing joint promises, right? It has to be either a team of people proposing the promise, or else a team of people has to be accepted the promise. Fine. Then the next one is several promises will make to a single personality, right? Promising to a single personality to perform. That is what you call as, if there are 3 characters like A, B and C, A and B are making promises to C, right? Then the third case. Now you should know, right? Several promises will make several promises. I mean, it can be either a promise or a promises to several promisees. Let's add D as well. A, B, C and D are there. So A and B are promisers, so which promise to perform some work to the promisees called C and D. There are 2 types of, 3 types of altogether performance by the joint promises. Fine. So how can you demand now, if you received a sort of a joint promise, right? How can you demand for them? There are ways, right? In an event which several promises are promised, right? How can you demand? Now let's say, as you can see, then the demand has to be made by all the promisees, or in the case, emphasize on this, or in the case of death of a promisee, be careful, the legal representative of such deceased has to be with the rest of the promisees. Now, with the absence of one promisee, even you cannot make any demands, right? Anyway, you know, if a party has given you, a promise, so the party has failed to perform that well. So, being the promises, you are going to demand for them, right? Promiser cannot demand for the promise, right? Because he's the person, or it's the person to do the promise, right? So, because of that, promisee can only have the right to demand for the promise, and if a person has already been deceased, or else if a person has met with an insanement, so the legal person, as I told you, no, the legal personality or the legal representative or the law officer can represent him in that particular promise. Then, with the involvement of that particular legal personality or attorney, all the promisees can ask the promiser or demand the promiser on the promise. Okay. And parties to perform the joint promises. The next slide. Who are the parties to perform the joint promises? By attaining to this type of agreement, let's call that as a joint agreement, joint promise, all the joint promisers has to perform this. If there are more than two parties, let's say, they have to definitely conduct or perform this promise, right? And any one or more joint promises may be compelled to perform, right? There can be one or more parties who are compelled to perform, right, by the promises. So the personalities has to perform it, right? There are some sort of special duties and responsibilities, can be because of the personality, can be because of the ability to do that, right, with the competency. Now let's say it's a crew of, let's say, the professionals, where an engineer is in that particular promiser group, right? So the which can be performed by the engineer cannot be performed by the accountant. So because of that particular in that particular promise, the engineer has to perform that particular duty, right? So that one person is responsible to perform that particular task, right? That is for the fulfillment of the duties and responsibilities, right? Then the third one is, let's say, right of contribution inter se, it's a phrase, right? That is called share of liability between the joint promisers. Now let's say, if somebody has claimed, let's say, in a sort of negligence misstatement or negligence, let's say, under the law of torts, someone has sued on you, sued over the courts, and because of that you may have to pay the penalties, right? So in the case where there are three parties as the promisers and one party as a promisee, so definitely let's say, the compensation or the amount to be paid to that particular promisee has to be bared by three people, not by one person. So that is what we call as right of the contribution inter se, which will divide the liability between the parties involved as the promisers, right? You don't want to get another shit on your face, okay? Frankly speaking to you. Then share of loss by default in contribution. Now basically, if there's any losses, it has to be bared by the number of parties involved as the promisers, right? It's same like the when it comes to the sum of the partnerships, of course, those losses will be divided equally to all the shareholders or the partners. Not that is based on the agreement. If you have agreed on the proportion of the capital that you have employed in a business, that's up to the persons who agreed. to compensate over it. But here, that will be equally distributed among the people, those who have signed as the promisers of this contract. Right. Then the next one is effect of release of one joint promisor. Let's say, because of, let's say now, one of a person can be, while performing the promise, while conducting the promise, one person may be ceased his duties and liabilities from this particular uh, promise, in case of, let's say, he's not in a position to perform, or his lack of knowledge, or whatever a reason, he will, like, it's like resigning from a position, right? So because of that, but sure, for sure, the person who tries to seize his liability has to get the fullest consent from that particular promisee. If the promisee won't allow you to go out by being a promisor, you cannot do anything, right? That has to be bared by you, I mean being the promisor. Okay, fine. I know these are much complicated, but of course you can refer this presentation again and again, and you can watch this, because once after I live casted this, this will be recorded in my channel. So you can go and refer the information, and if you have any concerns, you can mail me or text me, and also you can do the live chats while I'm doing the presentation. So you can get to know about more things, right? And also you can Google it and see what are the validity of these statements and so on and so forth, right? Then coming back to the lesson, we can see the assignment of contract. So this is going to be the last topic that I'm discussing today. So basically, assignment of contract. Is there any possibility of assigning some of the duties and responsibilities to another? Yeah, for sure, because you have, right? You have the right, because you don't want to, because designatory, let's say, if you being an employee, let's suppose most of the people, those who are watching my videos are the professionals, right? So you being the employees of some companies, or you being the managing directors and entrepreneurs of your own organizations. So you might have heard, if a person tries to resign, there should be a personality to assume his duties. Now, what is happening in the ministries, of course, during this time, right? Some of the governors are appointing, maybe, right? See, so that is of assuming the duties, assuming duties, or let's take an example of assigning some of the duties and responsibilities of a person. But be careful. If you are bound by the law as a promisor, there are possibilities where you can, there are some of the circumstances where you can assign your responsibility or the liability, but of course, not in all circumstances. Okay. So transfer of contractual rights and the liabilities to a third party with or without the concurrence of the other party to the contract is known as assignment of contract. So for that, in the case of, let's say, in some circumstances, you may also need the consent or the assent of the promisee. But of course, in some of the cases, you will be exempted from that particular requirement, right? Case by case basis. Fine, we'll get to know about this thing. So nature of assignments, right? The following has to be considered. Basically, you should consider all these things as mentioned in the presentation. Contract involve personal skills cannot be assigned. Of course, as I told you, now being let's say being an engineer, the task he is assigned to perform in that particular contract cannot be assigned by another or let's say another profession, right? An accountant, a manager, or as a doctor, medical professionals. No, you can't, right? That particular thing has to be performed by that person, right? So if something is impersonal, or some what do you call, the bound is in person, so the contract cannot be assigned. Okay, these things are often happening in construction sites. You may have seen in some cases of signing the agreements of the construction contracts, the party who has involved as a construction engineer, their people cannot resign until the project is getting over, right? Until the project ends, they cannot resign from their positions, even though they have resigned from their company, but it has to be, it has to be carried out under his observations, right? So that is called, the person's kids, right? Then obligations of the contract cannot be assigned without receiving the consent of the promisee. See, now in a case of death of something, of course the legal personality has to be there, but that is justificable. No? But when it comes to the obligations of the contract, the promisee has to give his fullest consent to, assign some of the duties and responsibilities of the promise to the other party. Then right and rights and the benefits can be assigned if the contract is not in a personal nature, right? You can understand that. Okay, so then the assignment by the law can be made at a death or a personal or an insolvency. Now when it comes to an insolvency, I told you about the death. Insolvent in the sense the businesses can only be insolvent where the persons can be bankrupt. Most of the cases I have seen, some of even the professionals are using these two words together for the same case of, let's say, the company has bankrupt. It's wrong. Company has to be insolvent and the person is going to be bankrupted, right? You cannot mess these two words up. So, in an insolvency, once you know that you don't have the assets to pay over your liabilities, you must reveal it now. Anyway, once after you got a individual, let's say the independent auditor's report, that will also decide to, pay over whatever the liabilities that you have through, selling your assets. So in that case, an administrator will be appointed by, or that will be appointed by the regulatory authority. Then after that, in the case of insolvency, that will be publicly notified. Your company is insolvent. Under that circumstance, of course, you can, even without the consent, it has to be done, right? Because if you are bound by your personal wealth, you have to pay that. Otherwise, by, after once they, realize some of the incomes through your sources, whatever the realizable things, they will do the necessary promises performed with the involvement of the legal representatives. Okay, so I know it's very hard and I was very rude. Yes, I know. So we will be publishing another video which will discuss on the rest of the things of promises and the performance of contracts and especially the breach of contracts as well. So keep your eye on that, and we'll be having another useful session in our next video. Thank you very much. Hope that you all enjoyed. If you do have any concerns, let me know. Also, it's a bit tired day for me, so hope you all enjoyed. Thank you very much.